Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll talk about a specific aspect of Section 109 of the Australian Constitution as decided by the High Court of Australia in a case called the Kakariki Case. Today we will look at what has been identified as an operational inconsistency under Section 109. The idea from this kind of inconsistency of laws is taken from the Kakariki case from 1937. And I think it is easier to understand what the operational inconsistency is by paying attention on the decision in this case. So let's start by analyzing the facts and the issue in the Kakariki. Generally, the case involves the removal of a wreck from a steamship called Kakariki. The Kakariki had sunk in Port Phillip Bay in Victoria after colliding with another steamship in January 1937. Now, Section 13 of a Victorian law provided for the removal at the instance of a state authority of any ship sunk in a port within the state and that had not been removed by the owner. But the thing was that Section 329 of a Commonwealth Act makes a similar provision, saying that the Commonwealth can remove any ship sunk on or near the coast of Australia. So, who could remove the wrecks? Did the power to remove the shipwrecks belong to the Commonwealth as per the Navigation Act, or to Victoria according to the State Marine Act? Isn't there an inconsistency between the laws of the Commonwealth and the law of the states? Look, so far in our videos we have dealt with the provisions that can be contrasted with the other. Sometimes they determine opposing conduct, other times one alters the rights given by the other law, and yet other times one law enters into a field that was regulated by the other. But here we are facing a different scenario. Do you see what's happening? Both laws are given the power for someone to do something. They are enabling provisions. There's no obligation or duty being imposed by the provisions of the Commonwealth or the state laws. They provide for a freedom. And on the liberality of the provision, the Commonwealth or the state authority may remove the shipwrecks or not. They don't have to do it, but they can do it. And by the way, no action had been taken by either authority by way of actually beginning to remove the shipwreck. Both could do it, but at that particular stage, in that case, no one had actually started doing it. So here are two things to highlight, right? First, the meaning of the operational inconsistency, and second, whether the law of the Commonwealth had covered the field and made that state law indirectly inconsistent with it. So let's start with the first dimension. What is this operational inconsistency? Just before getting to the point, let me emphasize something extremely important to understand the result of this case. No authority, either from the state or the Commonwealth, had taken action to remove the shipwreck. Remember this. So, in analyzing the case and whether there was an inconsistency between the laws, according to Section 109, Justice Stark said that no conflict or inconsistency between the law of the state and that of the Commonwealth can arise in such a case unless one or other authority interferes with or obstructs the act of the other in removing a wreck. If there was no conflict in practice, there would be no conflict of the laws. And the High Court of Australia ultimately decided that, in this case, there was no inconsistency between the federal and the state laws because of that. Operational inconsistency occurs when the two laws give the same powers to different public authorities, and since these are liberties that can be used or not, no inconsistency or conflict would occur unless one of the sides acted upon it. The inconsistency between the two laws would only appear if there was a practical inconsistency of conduct. As Justice Dixon explained, his view of inconsistency was substantially the following. When a state law, if valid, would alter, impair or detract from the operation of a law of the Commonwealth Parliament, then to that extent it is invalid. Moreover, if it appears from the terms, the nature or the subject matter of a federal enactment that it was intended as a complete statement of the law governing a particular matter or set of rights and duties, then for a state law to regulate or apply to the same matter or relation is regarded as a distraction from the full operation of the Commonwealth law, and so as inconsistent. And thus, if there was a simultaneous attempt by the Commonwealth and state authorities to remove the same rec, an inconsistency could arise. But that would be a practical type of inconsistency, an operational inconsistency. If that was to occur, then the state law would be invalid according to section 109, because then, and only then, an inconsistency would appear. The fact that no practical or operational inconsistency had happened meant the High Court found no inconsistency between the two laws. As Justice Abbott acknowledged, laws may overlap, but they don't necessarily conflict when they overlap. Now, what about the second dimension? Was the Commonwealth covering the field and thus invalidating the state law? As we have seen in our previous video, there would be an inconsistency if the scope and object of the federal law was such that prevented the states from legislating about the same subject matter. If the Commonwealth law has the intention to cover a whole field, the state law that enters that field will be found to be inconsistent and thus invalid according to section 109. Was this the case here? Justice Stark said in this case that the removal of the recs does not require a uniform legislation. Moreover, the language used by the law of the Commonwealth did not reveal an intention to fully regulate the matter. And even further, the law of the Commonwealth was broader than the law of the states. If we take all that into consideration, then there would be no inconsistency of the type of covering the whole field. Hey, you know what? Maybe it would be a good idea for you to understand the covering the field test better. So why don't you click the video that is appearing on your screen, and I'll see you there. Until then, ciao.